Hello everyone, my name is Pawan and I welcome you all towards our YouTube channel Art of Law, and we are starting with our preparation for All India Bar Examination. We'll be going with all the subjects in depth so that you will be able to clear your bar exam in a very simple and easy manner. Now, so today's video we'll be covering up on the important law, that is on Indian Evidence Act, which is also known as the Bharatiya Sakshya Abhinayam 2023. We'll be covering highest scoring area for the All India Bar Examination. So we'll be covering everything in depth. Make sure that you are having Bar Act with you. So today we'll be going through important provisions and sections from the Bar Act, and from there we will parallelly try to prepare for your exam. So today's video is going to be very short because I just want to show you how the classes are going on and how you need to literally try to prepare for it. And also, I'm just happy to tell that we're also started with our classes. You can also reach out towards my team. For the live classes, you can just drop down a text to my team. I've provided you the phone number as well as contact details below. Please do reach out for the classes in a very affordable prices. We are teaching for All India Bar Examination. It's going to be really helpful for you. Do not miss it. Last year there was a huge amount of failure of the students, but this time please not get any chance of missing it. So on that count, we'll be starting with our presentation as well as learning for the Indian Evidence Act. Okay, I hope all of you can see my screen. Now, as said, this is our BAT. We'll be starting with the BSA. Okay, so Bharatiya Sakshya Abhinayam 2023. Okay, remember that the presidential assent it got on 25th December 2023, but however, it was enforced on 1st July 2024. Remember always the Bharatiya Sakshya Abhinayam, even though the presidential assent it was got on 25th December 2020. Just I underline on this particular aspect. Mention that it was enforced on 1st July 2024. There is high chance for your prelims exam they can ask it. Now, very important. Let's start with the first important section, starting with section 1. So it is basically telling that where it is applicable. It is applicable throughout India. So, but the act may be called as the Bharatiya Sakshya Abhinayam. It applies to all judicial proceedings in or before any court, including the court martials, but not to affidavits presented to any court or officer, nor to be the proceedings before the arbitrator. So this is not explicitly applicable within the aspects of what it is saying, that including court martials, but not affidavits presented to any court or officer, nor the proceeding before the arbitrator. So front of arbitrator, it's not applicable. But when you learn about BSA, it is applicable in all the areas. Okay, in all the areas of law you can apply the BSA except this provision which is said that whereas it is emphasized about it's not applicable to arbitrators. But now that's not important for today. Today we'll be learning about section 2 definitions. Okay, section 2 clause 1a, if you'll observe, we'll be learning everything one by one in detail. Now let's see what is this quote. The court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidences. So what do you mean by court? The court in this particular definition states about it is all judges and magistrate. Okay, it includes all judges as well as magistrates and all persons except whom the arbitrators, which we already discussed in section 1, right? Legally authorized to take evidences. So court means it is all judges and magistrates. Now when you learn about section 2 clause 1b, if you observe, that is conclusive proof. Now what do you mean by conclusive proof? See, if you learn about conclusive proof, I'll just tell you three important things parallelly you need to understand while learning about conclusive proof. One, you need to know what are the different kind of proofs available and why it is important. For you being a law student, you should be understanding what are the different kinds of proof, especially with an aspect of presume. Okay, so the three important aspects which you need to know. One is may presume, shall presume, and conclusive proof. Now, what do you mean by this may presume? So I'll just come back over here. Conclusive proof, I'll be just coming back quickly. But first, I'll show you what is this may presume. Okay, let me go to section 2, clause 1h. So then you'll be understanding what I'm exactly trying to convey. If you observe may presume, whenever it is provided by this abhinayam that the court may presume a fact, it may either regard such a fact as proved unless and until it is disproved, or may call for proof of it. So may presume is nothing but it's discretionary. Okay, it can be rebutted based on the facts. Now if you just say it reputed based on the facts, like for example, if Pawan takes loan from Kamal, okay, if Pawan takes loan from Kamal and there is no kind of agreement signed between me and Kamal. Okay. Now, how will I prove to the court that there is some kind of transaction happened? If I'm looking at the statement of bank statement of Kamal, especially a huge lump sum of money, he's basically been withdrawn, then the court can believe that what this person is telling is correct. So it's basically discretionary until or unless Pavan is disproving it. If I am telling that if I'm bringing out new evidences, then I can basically change it. So that's called as may presume. Whenever it is provided by the Zabeniyam that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. Okay. So understood? No, either it can be disproved until if you're bringing any kind of new evidences. Now, what do you mean by the next important aspect? That is about shall presume. So, shall presume, I'm looking into my parallel barrack, so it'll be easy for me to give you the notes. That's why. Shall presume. Section 2, clause 1L. If you observe, shall presume means what? Whenever it is directed by this abhinayam that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. So, for example, Kamal sends legal notice to Pavan to repay. On invoice, court acknowledges that until proven otherwise. So, for example, Kamal is basically sending me a legal notice, okay, for asking me to repay, and he also presents an invoice front of the court. So by looking into that invoice, the court by default understand that yes, that there is some kind of transaction has been occurred between these both people, or there's some kind of an agreement these both have basically been done, and then invoice is basically generated. That invoice itself is presumed to be valid, okay, and it is considered to be mandatory in nature. The court really mandatorily considers it. That's called as shall presume. Now let's go back to our previous section 2 clause 1B, conclusive proof. Means when one fact is declared by the Zabiniyam to be conclusive proof of another, the court shall, on proof of the one fact, regard the other as proved, and shall not allow evidences to be given for the purpose of disproving it. For example, if there is any kind of birth certificate being provided by the court acknowledges it by the law itself. They will not go further investigate. Okay, the court acknowledges that what is basically being submitted is indirectly correct, and they will proceed with the proceedings. Okay, so this is what you need to know it. Now, what do you mean by this document? Very easy. Document means any matter expressed or described or otherwise recorded upon any substance by means of letter, figures, or marks, or any other means, or by more than one of those means intended to be used, which may be used for the purpose of recording that matter, and includes electronic and digital records. So documents can be what? It can be digital or electronic records. Very simple language, right? It can be letters, it can be figures and marks. So all this is basically documents. So you know what is a document, right? That same document you can submit as an evidence too. So if you observe, a writing is a document. So something has been written, that is document. Words printed, lithographed, or photographed are documents. So all these are, like, for example, printed, lithographed, or photographed. It can be a document. A map or plan can be a document. An inscription on a metal piece can be a document, or a stone in a stone, or stone is a document. A caricature you have seen, there's drawings and all this, there's drawings, and that can also be considered to be a document. And electronic records of email, server logs, documents, or computers is very important, especially if you want to specialize within the domain of cyber law. Like, all this is very important. Okay, for example, there's a cyber case between one person to another person, and there is a cyber threat has been happened from one person to another, but to their email, a series of transaction email series, if you observe, you'll be able to prove that, under, you can say that your honorable court, under section 2 clause 1D, document, this email should also be considered by the court, because there is some kind of fraudulent transaction being occurred, or there's some kind of fraud being happened over here. That also you can try to prove it over there. Now section 2 clause 1E, if you observe, evidence means and includes all statements, including statements given electronically, which the court permit or requires to be made before it by witness in relation to the matters of fact under inquiry, and such statements are called oral evidences. So something which you basically give orally is known as what? It's called as oral evidences. Now, all documents, including electronic or digital records produced for the inspection of the court, and such documents are called as documentary. So anything is submitting as a document is considered to be what? Documentary evidences. Now, what do you mean by this fact? Now, when you learn fact, there are three things you need to know. What is fact, fact and issue, and relevant fact. So three things we'll be learning. Very simple, yeah. So make sure that you are underlining, okay? All the explanation I'm giving you now, you need to just pause, underline, and write it down. Okay. Now, Fact means and includes anything, state of things, or relation of things capable of being perceived by the senses, any mental condition of which can be a consciousness. So, something which is basically being seen, or something which is of anything or relation of things capable of being seen by senses can be a fact. So, I'll give you an example. Okay, if Pavan sees Kamal breaking the window, if Pavan sees Kamal that he's breaking the window, then that is a fact, because what, that fact is seen by the sight. Getting it? So that is basically considered to be a fact. So I hope you all understood this simple understanding of what is this fact. So anything which is being seen, it is a state of thing, relation of things, so capable of being perceived by senses, that can be considered to be a fact. So let's learn what is this fact and issue. Very important. Fact and issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. So, for example, fact and issues means when a fact has happened, what, so here you'll be applying the terms like, for example, Pavan saw Kamal breaking into the window. Now here the questions about fact will be coming. Why did Kamal break the window? What did Kamal have in his hand? Did Kamal have any jewelry in his hand? Did Kamal steal something? Did Kamal kill someone before running out of the window? What, when, where, why, how? So all this, if you observe, what, where, when, why, how, everything is considered to be fact and issue. All the questions which now you see, that now is basically compromising in the fact and issue. Okay, that's simple as this. So nothing much to worry. It's like very easy. Now I'll just tell you even this relevant fact. If you observe relevant fact, yes. So it comes under section 2, clause 1. K, if you go, you will find relevant. A fact is said to be relevant to another when it is connected with the other in any of the ways refer to the provisions of the opinion relating to the relevancy of the fact. Okay. So in relevant fact, the court assumes it is true. So what is being submitted is considered to be true when certain kind of evidence has been provided, or when the court basically try to understand that, all that it has been provided is considered to be a relevant fact, when they have every kind of things, when the court believes that yes, for the 100% fact what is happening is considered to be the relevant fact, because that is a true incident which has been occurred. Okay, assumes, the court try to assume that it is basically true. Relevancy of facts, when it is assumed that the entire fact is correct or true, that's called as relevant fact. Now we'll be learning about, we completed this may presume, shall presume, and all. We have completed it. Now we'll be learning about what is this not proved, proved, and disproved. Okay, so very important, which I want to explain to you once again, that is about what do you mean by this proved. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers the existence or probably that a prudent man or under the circumstances of this one. Okay, so when the court feels that okay, something is existing and something which is being proved, then it is coming under the section 2, clause 1J. Now, what do you mean by not proved? Not proved means a fact is said to be not proved when it is neither proved nor disproved. So, what do you mean by not proved? When we are not able to tell that no, it's neither proved or misproved. When we are in that particular balance of void state, it is considered to be not proved. So, for example, if you, in the proved example could be about, for example, if A versus B, they sign an agreement, that is incidents that itself is considered to be proved. Why? Because they have basically signed the agreement between both of them, that is considered to be proved. Not proved means when it is not, neither when it is not proved or not proved, in that particular balance state is considered to be this not proved. Okay, neither proved or disproved, so that time they comes into this not proved. So when we cannot tell that whether the agreement is being signed or not, when that confusion void state is coming, it's considered to be not proved. So, and we completed this shall presume, as well as relevant is also been completed. So here ends our entire section 2, clause 1. We started with everything one by one, and I hope all of you understood very clearly about all the important aspects which we discussed for today. I hope all of you will be writing down all these respective sections in your barrack and preparing parallelly. Wish you all the best. Good luck. Just want to tell you, you can also join for our classes. We'll be happy enough to take the classes for you, guide you for your All India Bar examination. Our team will be happy to connect you. You can just contact my below team over here. Details are provided in the description box. All the best. Do very well. I'll be happy to cover everything in detail and prepare for your All India Bar examination. Please do not fail it this time. It's very important. You can join for the classes at any point of time, because we'll also be accessing you with the live classes and with For example, certain classes which you have missed, being mixed, we can also be providing you with recording, and mock questions also will be providing with previous year question analysis. So all the best, good luck. This is me, Pavan, signing off. Take care. Goodbye.